Thanks everyone for joining. Uh, this afternoon, we're going to be exploring the issues faced by those involved in the defense of medical malpractice claims. My name is Glenn Ferris. I'm the Managing Director of Healthcare Today, and I'm joined today by Neil Rowe, who is the Head of Practice at Mowlin Law, a boutique law firm specializing exclusively in the defense of medical malpractice claims, and our guest, Doug Walker, Medical Malpractice and Healthcare Practice Leader at multinational insurance firm QBE Europe. Neil has had more than 30 years of experience in clinical negligence and medical malpractice defense, and in that time has managed some of the most complex and high value claims in the sector, including catastrophic injury cases exceeding £30 million, multi-party litigation, and high profile matters such as pelvic mesh claims and the Patterson Group action. Doug, meanwhile, has had over 35 years' experience in the insurance industry, specializing in the healthcare sector for the past 25 years. At QBE, he provides insurance solutions for a wide variety of customers, ranging from large private hospitals to small clinics and individuals working in the healthcare industry. Now, today we will focus on the reasons behind claims inflation and how to mitigate the rising cost of a MedMal book, the growth of litigant in personal claims and how best to deal with their characteristics, and the increasing pitfalls of social media use by clinicians both pre and post claim. A little bit of housekeeping. There will be an opportunity to ask questions at the end of the webinar, so please put any queries you have in the chat box as we go along. Now, let's get started. So I'm going to start with you, Doug, straight away. I'm going to throw you right into the lion's den. We hear a lot about claims inflation. Can you describe what exactly is claims inflation?
Yes, thanks, Glenn. Absolutely. Claims inflation is the term given to describe the difference between the value of a claims award from one year compared to the value the next year. It is very much the same principle as general inflation. General inflation is calculated by comparing the cost of a basket of goods from one year to the next and seeing how much more expensive the goods were a year later. For claims inflation, you're basically substituting that basket of goods for the various costs and heads of damage that make up a claims award.
So why is claims inflation important for insurers specifically to monitor?
Well, monitoring claims inflation is crucial for insurers. Pricing models are based on there being an expected number of claims with an expected cost of a claim. And these values will be based on the cost of claims historically, so how much the claims had previously been settled for. Insurers need to factor in the rising cost of claims into their pricing models, especially as a claim can take a number of years to settle, particularly the large claims. They quite often take 5, 6, 7, 8 years before they're fully settled. So pricing models need to adjust the pricing each year to reflect the higher cost of a claim in the future. Now, insurers will target a profit margin of between 5 and 10% for every pound of premium they collect. So if claims costs continue to rise faster than the average increases in premium, then this will this will impact the profitability of the insurers. And over the long run, this might result in insurers either deciding not to write that business anymore, or even sort of just put in larger increases on which impact customers. Claims costs actually also have a direct impact on customers. Whether that's an individual surgeon or a large private hospital, the claims values influence how those particular premiums and those particular risks are priced.
Neil, moving over to you, what is the scale of claims in the UK and frankly, how big is the problem?
Yeah, thanks, Glenn. Thanks, Doug. And hello, everybody. Thanks for joining. Um, I'll just start with NHS resolution, if I may. Many of our attendees today will be fairly familiar with the numbers, I'm sure, but this is a huge problem. It's fair to say claims numbers have plateaued over the last few years, but in 2024-25, the NHS still saw 14,428 new claims. The annual cash payment was over 3 billion. The estimated cost of harm about 4.5 billion, and the contingent liability stood at a whopping 60.3 billion. The good news is that NHS Res resolved 83% of claims faced out of litigation, and only less than 0.1% actually went to trial. It's fair to say, as everybody knows, I'm sure, that maternity claims dominate. That's 1.3 billion of the annual payment, or 42% equivalent. And the average brain damage or cerebral palsy claim is now 11.2 million. So eye-watering figures. And not only that, but the costs associated with these claims are also extremely high at an estimated £538 million per annum. And the ratio of costs to damages in low value claims is now 3.7 to 1, so costs many more times than low value damages awards. And frankly, the cost of the government is now similar to nuclear decommissioning and state pensions. So, as we all know, very high on the agenda. Medical malpractice figures, on the other hand, are more difficult to come by due to the obvious proprietary nature of the data held by MDOs, insurers, brokers, and so on. But what we can say is that anecdotally, med mal claims are increasing also due to various factors, such as more private patient episodes due to NHS outsourcing, more patients simply choosing private treatment, maybe due to waiting lists. Also growth in private treatments, aesthetic, cosmetic therapies, and also private mental health services are growing as well. In addition, there's the expansion of the care home market. Now, it's fair to say that claims values in medical malpractice are overall lower in comparison to NHS, predominantly due to the impact of maternity I've described and emergency care and trauma. And thankfully, cat loss claims are relatively few and far between in the med mal market, but overall, the value of claims is growing. There's a system which clearly many people believe needs serious reform. There have been calls for no-fault schemes. Controversial, in my opinion. They may not work in the UK as opposed to Scandinavian or New Zealand models due to scale and demographics. Another problem is the perceived double payment. So under Section 2.4 of the Damages Act, a patient is entitled to damages for care, for example, being paid privately. And calls to scrap that are controversial because, well, frankly, if you put the cost of private care back onto a cash-strapped NHS or social care system, it might make the problem worse. In addition, with regard to costs, the call for fixed recoverable costs for low-value cases of £25,000 of damages and below, in principle, in my opinion, can't really be argued against, but access to justice needs to be preserved, and there is huge disagreement, of course, over how low those fixed figures should be. So, lots to think about.
Following on from that, Neil, what are the specifics of medical malpractice claims that you are seeing increase cost of settlement and development?
Yeah, if I cast my mind back, Glenn, over the last decade or so and think about legal developments, some commentators would say that particularly the Montgomery judgment in 2015 on informed consent produced a rise in consent claims, especially given its retrospective nature concerning how consent was taken in the latter parts of the 2010s. Arguably, also equally, the introduction of Bailey and the expansion of the legal causation but for test to include material contribution has had an impact. And also, meantime, I think I'd say that limitation defences are becoming, unfortunately, a thing of the past. Section 33 prejudice doesn't often run these days, particularly when you see cases where even death of a doctor is not enough to tip the balance. In catastrophic loss cases, I think we can safely say that longer life expectations in the population means that multipliers, when calculating special damages for adults and particularly children, are increasing. Obviously, that's subject to the vagaries of the personal injury discount rate, which fortunately has come down recently. And also recent development in the law, we've seen the harmonisation of the lost years law, which now allows children to claim. But generally, though, overall, I'd say that everything is just simply more expensive. Multifactorial, of course, but probably mainly due to the pandemic, cost of living crisis. And I think we see this most in the cost of domiciliary assistance. For those cost of care claims, The hourly rates involved have more than doubled in the last decade from, say, roughly £16 an hour in 2016 to around £32 or more today. And in particular, with regard to specialist nursing care, where that's required in certain cases, from, say, in 2016, about £22 an hour up to over £40 an hour today. So, doubling of those costs. And in addition, I think most practitioners would also recognise that many, if not most, heads of loss claimed have increased. So that's the cost of aids and equipment, prostheses, talking about the cost of assistive technology and various therapies such as occupational therapy, physiotherapy, and speech and language therapy. It's quite simply everything just is more expensive.
Question to both of you. How do you mitigate these previous points when you're managing claims?
I'll go first on that one, Glenn. So I think if effective and efficient claims handling is really important here. And I would say this is where your choice of insurer really makes a difference. It's what you're buying your policy for at the end of the day, is that claims expertise. At QBE, we advocate for early notification of a claim or a potential claim, and then working with your insurers to manage that. Early investigation of the incident is crucial to get a full understanding of all the circumstances. So reviewing the medical notes and obtaining statements from the clinical staff involved can really help the defence of a claim, as that information is going to be much more accurate, much more reliable to be used, and the events will be clearer in the memory of all the staff involved. So having a good understanding of the facts makes it clearer to determine the strategy that you need when you're managing that particular claim. If the liability prognosis is not good, then the strategy may well be to make an early admission of liability and attempt to settle without incurring lots of additional legal costs. However, if a claim cannot be settled early or is contentious, then we would need to bring in some lawyers to respond as part of that formal claims process. And I think this is where the choice of law firm is equally important. And I'll bring in Neil to talk about some of the strategies that he could use to manage these claims costs.
Yeah, thanks, Doug. You are absolutely right. And of course, I would say that, wouldn't I? But yeah, I mean, from a lawyer's perspective, I'd say that one of the main things now more than ever is actually immediate collaboration with the claimant's solicitors. So, from a defence perspective, the first thing I'll do upon receipt of a claim is pick the phone up to my opposite number and just have a good chat about how they see things. What does their client want? Where do they see this going? And strike up that relationship, because reducing litigation friction ultimately is only going to save shelf life and costs at the end of the day. And moreover, I'm sure all practitioners who handle med mal cases will recognise that it's expert driven. So, really instructing the best quality experts on liability to ensure defensible cases are defended robustly, or if there is risk and there's a meritorious case, that's identified, as you say, Doug, as early as possible and offers are made. And equally, when one comes to quantify the damages to be awarded, instruct those best quality experts to ensure that the needs are reasonable and not just desired. In addition, I'm sure everybody's aware that fraud and exaggeration is a fairly hot topic, when it comes to personal injury and clinical negligence litigation. So, on the defence side, certainly we'll be robustly investigating any suspicion of fraud, exaggeration, etc., using social media where necessary. And I'll come on to that in a moment. It's fair to say that over my time defending claims, I've seen some fairly tenuous or luxury heads of loss, might I say, items such as swimming pools, boats, holidays of a lifetime. And of course, they do need to be, investigated and properly challenged. And in addition, differentiating claims for mental anguish as opposed to those which are actually diagnosed or diagnosable psychiatric injuries. And let's not forget that once damages are paid, have a robust look at those bills of costs. Frankly, for me, I would always seek to look at without prejudice schedule and negotiate costs before the costs of legal cost draftsman are actually incurred.
That seems like a good opportunity to jump onto our next section, which is looking at litigants in person. And I think probably the most important question, straight of all to you, Doug, is what is a litigant in person claim?
Thanks, Glenn. Yeah. So this is more than just a patient bringing a complaint. Obviously, patients complain and they inquire about their medical treatment and they might be unhappy with it. But this is actually the stage further. It's where they've actually brought a formal legal process that's been started by the patient who becomes the claimant, but they do not have any legal representation. So they are representing themselves.
So, in your portfolio at QBE, are you seeing a rise in litigant in-person claims?
We definitely are. I would say 10 years ago, they were pretty much unheard of. It was a once in a year type scenario. But these days, we do see quite a few litigant in-person claims in our portfolio. And I think there's probably a number of factors which are influencing the increase in litigants in person. Um, the patients might struggle to find a law firm who wants to take on the claim. Claimant law firms will operate on a no-win, no-fee basis. And if the liability is not clear cut, then there's a risk to the law firm of taking on that case. If the value of the claim is low, combined with the liability question, then it might well be just too much of a risk for the law firm to take on. So the patient won't be able to find any legal representation to take them on. Um, there might be some patients who just want to retain a larger proportion of any award that they get. So rather than sharing the success fee with the claimant law firm, they might feel like they can do it themselves, and they can run the case themselves. So they don't have to share any awards. And I think the biggest factor around this is the increase of AI software that can provide the legal support, the technical support, which allows people to start that claim process themselves. The problems, though, with claimants using AI, like anyone using AI for anything, is that it needs someone to sense check the answer before sending off. If the AI is not accurate, then it can lead to plenty of back and forth, correcting the documentation, correcting the process, which just elongates the handling of the claim and ultimately will drive up the cost. So I would say, if the claim does progress as well and the litigant in person is using AI, then they'll run into additional complications around assessing medical records, things like that. So they can be quite problematic for us to handle and manage because it just goes outside that normal claims process.
Thanks for that, Doug. Neil, just over to you. At Mowlin Law, do you manage litigant in-person claims differently? And if so, how do you?
Thanks, Glenn. Yeah, in short, the answer is definitely yes. I think it's also worth just adding that if and when fixed recoverable costs do actually come in, it's strongly thought that the numbers of litigants in persons will spike even further. Um, for now, can I just sort of add one or two points with regard to patients bringing complaints or claims before they become correctly defined by Doug as litigants in person? Because for some of our clinical practitioners out there, it's quite a challenge to know how to deal with patients when they're dissatisfied. So just a moment on that, if I may. So before a claim is actually brought by a litigant in person, it's often best to try and find out what those patients actually want, because behavioral studies have shown that many dissatisfied patients are not just looking for compensation alone. Quite often they want reassurance that what happened to them can't happen to somebody else. So it's important to invoke the duty of candor, possibly involve that patient in a PSERF investigation, make suitable apologies or explanations. Remember that saying sorry is not a legally binding admission of liability. And of course, make any necessary system or document changes. And from the financial perspective, consider promptly any requests for refunds or pay for revisions. If you're going to make a goodwill payment, take some advice and be careful of CRU repercussions. But if a practitioner does receive a complaint, then obviously they need to follow the applicable complaints process, ensure that the patient's voice is heard, because many complaints arise in the first place because of communication issues and patients not feeling that feedback was ever heeded. Remember also that the importance of documentation can't be overstated. It can nip claims in the bud. Litigants in person's recollections of the treatment they received might actually be mistaken in some cases, and good documentation may actually show, in fact, what actually happened, and means that a claim can't eventuate. Meetings very often face-to-face can be best to try and rebuild relationships, and if so, of course, adopt a sympathetic tone, use layman's language, agree to recordings of meetings if both are aware of the recording being taken, but be careful with AI transcription errors. And of course, as Doug's already mentioned, anybody using an AI transcription or tool needs to check the contents carefully. Very often in med mal cases, there might be a number of separately indemnified parties in a private setting. So upon receipt of a complaint or the initiation of a claim from a litigant in person, make sure we know who is acting for whom and who indemnifies which practitioner, because very often it might be possible to immediately redirect a complaint or claim to a separately indemnified hospital entity, an RMO, or possibly nursing staff, depending upon the circumstances. And as Doug said, early involvement of panel lawyers is a possibility. Yes, there'll be a cost, but actually it might be better to use panel lawyers to try to educate in the nicest possible way litigant in person, control the process, and therefore limit costs and time, therefore equating to good value. But as Doug's already said, unfortunately, sometimes claims can't be avoided from litigants in person. And if a litigant in person does serve what purports to be a letter of claim, well, make sure that they're directed to the law, the pre-action protocol, so that they can review the letter they've sent and maybe redraft so it fulfills the correct template. But more often than not, refer them to the case of Pantelli and that line of authorities, which says that in professional indemnity cases, a claimant really must get independent expert evidence on breach of duty and causation in order to prove the grounds for the claim in the first place. And very often, referring to that case can be effectively a cost deterrent, because it could be very expensive. It is very expensive to get those expert reports. Alternatively, it might be enough to just use your consultant doctor's comments in order to dissuade the claim from proceeding beyond the letter of claim stage, or possibly use comments which may already have been provided by other eminent consultants in the pathway to try to persuade the letter of claim to be withdrawn. If that doesn't happen and that hasn't succeeded and a claim form is actually issued, well, the lawyers have a number of techniques available which may enable the claim to be nipped in the bud. So first of all, think about the jurisdiction when filing the acknowledgement of service form. It may be necessary and more than appropriate at that point to apply to strike out. Insufficient grounds for the claim may have been set out on the claim form, and if so, an application for summary judgment may well be appropriate. And additionally, just check service, because if service has been made on the wrong address, for example, depending upon who you're acting for, then it may be possible to get that set aside as well. So one or two tips there, both pre and post claim.
Brilliant. Thank you, Neil. Let's move us on to the next section. And just a quick reminder that if you have any questions, there's an opportunity to ask some. Pop them in the chat, please. There's a Q&A section, and we'll get to them in a little while. I would like to talk about the pitfalls of social media used by clinicians. It's an increasingly growing trend. Doug, in the first instance, why do clinicians use social media, and what are the benefits to them?
Well, Glenn, and I can sort of, not being a clinician myself, I can only sort of speculate on this, but I think there's, like everybody, so much is on social media these days. So I suspect many clinicians feel like they need to have a social media presence, an online presence. It can, of course, be extremely beneficial to them if it's used in the correct way. Many clinicians will use social media just like we all use it in a work environment to either promote their own, promote themselves, build their reputation amongst peers and amongst sort of customers, clients. That could either be through knowledge sharing, using it as a channel to discuss some research that they might have been involved with, or generally producing some sort of thought leadership content just to say raise their own profile. But they could also use it to just comment on their own takes on public health campaigns, public health issues that are in the news, such as Ebola outbreaks, things like that, and generally just sort of generally creating their own personal branding, which is trying to enhance their own career opportunities. I think these days you can sort of write a review on almost anything online, and surgeons and healthcare providers are no different. And I'm sure there's lots of patients who will look up online to read reviews about healthcare providers or surgeons that they are potentially thinking about using. So I think really, social media is here to stay, whether it's the traditional social medias like your Facebooks and or it's the more business related ones like LinkedIn, but there's plenty of opportunities for clinicians and surgeons to put their own views out there to the wider public.
I mean, a powerful tool indeed, but not without potential problems. Neil, what would be the areas that clinicians need to be aware of, and what are the potential pitfalls?
Yeah, this is a really challenging and evolving area for clinicians and, in fact, for private hospitals. So, I mean, first of all, just a word about customer review sites. Everybody strives for that 5-star rating, but, very often the higher the profile of the clinician, the more difficult it can be when lots of people jump on the bandwagon and start criticizing. Um, Platforms like Doctify won't actually remove an adverse review for a doctor just because it's negative. They will if it's deemed to be fake information or spam or fraudulent or threatening, defamatory, or it intends to harass. They will also if the patient's not a true patient and there's a conflict of interest. Perhaps they've been put up to it to make it a positive review. And they will, of course, remove a review if a patient asks for it to be taken down. But if a review is legitimate, albeit negative, the doctor will be encouraged to respond professionally. And therein lies one of the bear traps. GMC guidance is that any response should be limited to an explanation of the doctor's legal and professional duty of confidentiality. And if you post in reply, then the clinician risks an escalation on the site. Very often it's better to speak privately, I'd suggest. And lots of doctors have often asked me, well, what if a patient has said bad things about me? Have I got a remedy? Well, possibly in defamation, if a patient won't take down a post. So something may be defamatory if it's untrue, if it's published to a third party, or obviously more people if it's on a website or a platform, or if it's caused or likely to have caused serious harm to a doctor's reputation. Well, clearly, what constitutes serious harm could be open to debate, but a patient would say, well, hold on, it could have been true, it was my honest opinion, or in fact, it's in the public interest. So, a doctor threatening libel action or possibly seeking NDAs around a negative review is perhaps a very tricky escalation and could be very costly. It's fair to say that any online activity demands good professional conduct. GMC guidance is set out in good medical practice, and they're using social media as a medical professional guidelines. And in any post or message, a healthcare professional must be honest, can't misinterpret matters, and shouldn't bully, discriminate, or harass. But be careful if entering into a dialogue or messaging patients privately. You've got to heed professional boundaries. Remember, any text or messages flowing between a patient and the clinician are ultimately potentially disclosable in any claim or legal action. So if any contact is made privately, it's often best to redirect to a proper healthcare setting, such as the practice website or maybe the doctor's PA if they have one. Always remember, I'd say to a healthcare professional, how your communication would look equally to your private hospital or to your colleagues, the GMC, or the public at large. And it's really important to ensure that patient confidentiality is maintained at all times under the GMC guidance. Remember, patient information must not be disclosed unless there is specific consent to that information and the context in which it's disclosed. And don't forget, messages once passed to patients can then be passed on by them, waiving privacy, which can then cause reputational problems. So, very often, messages can be difficult to contain. So, the risk for clinicians are fitness to practice issues if they're being unprofessional online or there are breaches of confidentiality. And if I were to say anything or one thing, it would be, would you read that out in court? So perhaps think before you actually post and check your settings. If unfortunately a legal claim is made, then obviously at that point be extremely careful. Before saying anything at all, please defer to your brokers, insurers, or your panel lawyers if appointed, so that you can be sure that no rights are prejudiced and that you don't say something which may come along later, as they say, and be read out in court. So yeah, it's a minefield, Glenn.
I feel like we barely scratched the surface, but I'm a journalist, so what do I know? Let's leave it open to any questions now. We may have covered everything in as much detail as the participants would like to see. Don't currently have any questions there, so if you have anything, please quickly tap away on the keyboard. Otherwise, we won't take up too much more of your lunchtime. It gives an opportunity whilst we're here to just say that if you have any further questions, please get in touch on any of these email addresses, LinkedIn addresses, or phone numbers, or anything like that. I can direct any questions that you may have to Doug and to Neil. Otherwise, I think it's probably a good opportunity to wrap up. We've done a tight 30 minutes there, so I think that's pretty great. So just leaves me to say thank you for joining us today. Thank you to Doug and to Neil for sharing your knowledge and expertise, and have a great rest of your day and week. And please, as I said before, get in touch if you have any questions. Thanks very much.